last application please to direct me to file an affidavit since been applied within the party. 24 दी वर्ष कर दिया आपके पास और आती पॉलिटिकल के some of the information of the interprocess are not in Orissa.
Let it come after vacation. Vacation.
Excuse madam.
Yes.
Item 73.
Yes.
Co-appellants.
What do you want?
I came to know appellant number 2 died in the meantime.
33, yeah?
Lordship. And I have to take instruction about other 2 appellants, status of the 2 appellants. Well, I have written the letter, no reply was yet received. So let it be after vacation, Lordship.
1 minute. There are 3 appellants, huh?
Yeah, they have been convicted under section 2G of the.
But appellant number 2 has died, huh?
And I came to know. So far as other appellants are concerned, I have to take instruction, Lordship. Therefore, I am seeking time.
Mr. Samantara, the counsel for the appellant submits that appellant number 2, he has oral instruction regarding the death of appellant number 2, and he wants to ascertain regarding the well-being of the other appellants. Huh? This is the matter. Yes. Yes.
Obliged.
Yes. Yes.
You mentioned item 1.
Ballot. Here, ballot. Ballot may see. This case where ballot I was laying upon Exhibit A.
Okay.
The statement which was recorded by the investigating agency and the statement of PW5, the father of the deceased, which was recorded on 16/1, very first instance in the UD case. Initially, UD case was registered of 1 of 92. There, the statement was recorded. But may kindly see the statement recorded on 16/1/92. I think that has been exhibited as Exhibit A.
UD case. UD case is registered on?
Ballot?
UD case registered on?
UD case number 1 of 92, registered on 15/1.
1 of
2092.
1992. Registered on?
15/1, after the death of the deceased.
15/1 to 1994.
92.
1992. That is Exhibit A.
I think so. Because it's not there in the record. The Exhibit A reveals that I have no objection. My daughter and my son-in-law, they were pulling on well. They were leading a happy conjugal life. So death may be an accidental, as stated by the in-laws.
But
so
where from you got this version, if you have not read it?
I have taken the copy.
Para 16, in the para 16 of impugn order.
Judgment. Just say it's a written version. It's not a written statement of PW5. This has been recorded under 171, or it can be termed to be recorded during inquiry of UD case number 1 of, because in unnatural death cases filed, UD case inquiry is being conducted.
Yes.
Well, let me see. I have stated so in my note also.
Let us see how the trial court deals with para 16.
Mallet.
The defense makes an attempt to show that it is just a case of accidental fire. Nothing on record to hold that the case of
Exhibit A, where this is the father at one occasion expressed his having no suspicion over deceased. Deceased death inconsequential.
Physical violence. Even spoken the word causes mental torture and asking the wife to face the dowry amount of the cruelty, the contents of the letter, exhibits also this lady is also. That is, the only reference is this.
Mallet.
Para 16.
Mallet. And I have stated in my note, the note which I have prepared, Mallet, I have stated so. Though PW, though in the judgment it has been mentioned that it's a one occasion expressed he is having no suspicion. I have stated so, my lord, that it's not, it's a statement recorded under 161 by the investigator
Under that UD case.
in the UD case. Even in 16, after the case was registered, again, he was examined on 16.3. That I was also verifying. There also he has not stated so.
Statement, 161 statement.
My lord?
FIR registered one.
No, this Chaturabhuja Chaudhary,
Now, in this case, FIR registered on
FIR was registered on 19.
on 19/1/1992.
Right.
UD case is 15.
Right.
19. 164, one statement in this FIR recorded.
My lord?
161 statement in the FIR in subject.
In the present case, my lord, that was recorded on 15/3/92, my lord.
It can't be because the FIR is registered on 19/1.
My lord. That I also stated 3 months after. That was the argument advanced there in the lower court also.
15/2.
15/2 or my lord. That he has also admitted, my lord, in the evidence. PW5.
PW5.
My lord. And most peculiarity, my lord, this either with regards to Exhibit A, with regards to Exhibit 4, with regards to Exhibit 5, not a single question has been put. And the Apex Court, and this
So the police examined me after 2 months.
My lord.
After the
My lord.
But immediate statement is that UD case.
My lord.
Where she
My
different
lord.
story
My
altogether.
lord. That is, may I read the statement, my lord? ମୋର ନାମ ଦୁରିଚନ୍ଦ ଅଗ୍ରୱାଲ ପିତା ସୋଆଂଶୋ ଆଦ୍ୟ ତା 16/1/92 ଦିନ ଖରିଆଲ ଥାନା ଏସ୍ଆଇ ବାବୁଙ୍କୁ ଦେବା ଜବାନବନ୍ଦୀ ହେଇକି ଯେ ଗତ 15/1/92 ସକାଳ 9:30 ସମୟରେ ମୁଁ ମୋ ଘରେ ଥିବା ସମୟରେ ଗ୍ରାମର ଶଙ୍କରଲାଲ ଅଗ୍ରୱାଲଙ୍କ ଘରେ ପାଟିତୁଣ୍ଡ ତାଙ୍କ ଘରକୁ ଯାଇ ଶୁଣିବାକୁ ପାଇଲି ଯେ ମଧୁର ଲାଇକ୍ ମୋର ଚତୁର୍ଭୁଜ ଚୌଧୁରୀ ପିତା ସୋଆଂଶ ଏସ୍ଆଇ ବାବୁଙ୍କୁ ମୁଁ ମୋର ଝିଅ ମଞ୍ଜୁଳାଲ ଅଗ୍ରୱାଲଙ୍କୁ ଗତ 3 ବର୍ଷ ହେବ ହରିଶଙ୍କର ରୋଡ ସୋଆଂଶ ଶଙ୍କରଲାଲ ଅଗ୍ରୱାଲଙ୍କ ସହିତ ବିବାହ ଦେଇଥିଲି। ତାଙ୍କର 2 ବର୍ଷ ହେବ ଗୋଟେ ଝିଅ ଅଛି ବର୍ତ୍ତମାନ ଗର୍ଭବତୀ ଥିଲା। ମୋର ଜ୍ୱାଇଁ ଏବଂ ଝିଅ କୌଣସି ପ୍ରକାର ଗଣ୍ଡଗୋଳ କିମ୍ବା ମନମାଳିନ୍ୟ ନଥିଲା। 15/1/92 ସନ୍ଧ୍ୟା ପ୍ରାୟ 8:30 ସମୟରେ ତାଙ୍କ ଡ୍ରାଇଭର ପାଇକମାଳ ଠାରୁ ଫୋନରେ ମୋତେ କହିଲା ଯେ ମୋର ଝିଅ ମଞ୍ଜୁ ଆଜି ସକାଳେ ପାଣି ଗରମ କରୁଥିବା ସମୟରେ ଶାଢ଼ୀରେ ନିଆଁ ପୋଡ଼ିଯାଇଅଛି। ତେଣୁ ମୁଁ ସଙ୍ଗେ ସଙ୍ଗେ ତାର ଅବସ୍ଥା କ'ଣ ବୋଲି ସେ କହିଲେ ଯେ ମଞ୍ଜୁକୁ ଖଡ଼ିଆଳ ଡାକ୍ତରଖାନାରେ ଭର୍ତ୍ତି କରାଯାଇଛି। ତେଣୁ ମୁଁ ଗତ ରାତି ପ୍ରାୟ 1ଟା ସମୟରେ ଆସି ପହଞ୍ଚିଲି ଏବଂ ଦେଖିଲି ମୋର ଝିଅ ଆଉ ଜୀବନରେ ନାହିଁ। ମୋର ଜ୍ୱାଇଁ ଓ ଝିଅର କୌଣସି ପ୍ରକାର ଗଣ୍ଡଗୋଳ ନଥିଲା। ଏହି ମୃତ୍ୟୁରେ ମୋର କୌଣସି ସନ୍ଦେହ ନାହିଁ। ମୋର ଝିଅ ମଞ୍ଜୁର ଶାଢ଼ୀରେ ନିଆଁ ଲାଗି ପୋଡ଼ି ଯାଇଥିବାର ମୋର ବିଶ୍ୱାସ। ଏହା ମୋର ଜବାନ।
That statement was made on 15.
16/1/92. My lord. Second statement, even my lord, the IO I was verifying after the statement was recorded on 2 months after again in that PS case, wherein he has stated, I'm reading that statement which is more elaborate. 15 ସନ୍ଧ୍ୟା ବେଳେ ପାଇକମାଳରୁ ଗୋଟିଏ ଫୋନ୍ ପାଇଥିଲି। ଫୋନ୍ଟି ମୋର ମୋର ଜ୍ୱାଇଁ ଶଙ୍କରଲାଲଙ୍କ ଗାଡ଼ି ଡ୍ରାଇଭର ସାହୁ କରିଥିଲା। ସେ ମୋତେ ଜଣାଇଥିଲା ଯେ ମୋ ଝିଅ ମଞ୍ଜୁ ନିଆଁରେ ପୋଡ଼ି ହୋଇ ଖରିଆର ମିଶନ ଡାକ୍ତରଖାନାରେ ଆଡମିଟ୍ ହୋଇଛି। ମୋତେ ନେବା ପାଇଁ ଡ୍ରାଇଭରକୁ ଗାଡ଼ି ଦେଇ ପଠାଇଥିଲେ। କିନ୍ତୁ ପଦ୍ମପୁରରେ ରାସ୍ତା ରୋକ ପ୍ରୋଗ୍ରାମ ଥିବାରୁ ଡ୍ରାଇଭର ସାହୁ ନ ଆସିପାରିବାରୁ ମୋତେ ଫୋନରେ ଖବର ଦେଇଥିଲା। ଖବର ପାଇ ମୁଁ ବ୍ୟସ୍ତ ହୋଇ ପଡ଼ିଲି ଓ ଗାଡ଼ି ଖଣ୍ଡେ ଯୋଗାଡ଼ କରି ମୋ ଚାକରକୁ ଧରି ଖରିଆର ଗଲି। ସେଠି ପହଞ୍ଚିଲା ବେଳକୁ ସକାଳ ହୋଇ ଆସୁଥାଏ। ମୁଁ ଖରିଆର ମିଶନ ଡାକ୍ତରଖାନାରେ ଯାଇ ପହଞ୍ଚିଲି। ଦେଖିଲି ଲାଠୋରର 15-20 ଜଣ ଲୋକ ସେଠି ଅଛନ୍ତି। ମୋର ସଢୁ ସଜ୍ଜନ କୁମାର ମଧ୍ୟ ସେଠାରେ ଥିଲେ। ମୁଁ ବ୍ୟସ୍ତ ହୋଇ ସଢୁଙ୍କୁ ଲକ୍ଷ୍ମୀ କାଁ ହେ ପଚାରିଲି। ସେ କିଛି ନ କହି ଚୁପ୍ ରହିଲେ। ସଢୁ was present earlier to PW5. ଅନ୍ୟମାନେ କହିଲେ ଯେ ମଞ୍ଜୁ ଗରମ ପାଣି ଆଣୁଥିବା ସମୟରେ ପୋଡ଼ି ହୋଇଛି। ମୋର ଝିଅର ଶାଶୁଘରର ଲୋକମାନେ ସେ ସମୟରେ ଚୁପଚାପ ରହିଥିଲେ। ମୁଁ ମଲା ଖବର ପାଇଲା ପରେ ଝିଅକୁ ଦେଖିବାକୁ ବ୍ୟସ୍ତ ହେଲି। ଅନ୍ୟମାନେ ମୋତେ ବୁଝାସୁଝା କରୁଥାନ୍ତି। ସକାଳେ ଖରିଆର ପୋଲିସ ଆସି ମୋତେ ଶବ ଦେଖାଇଲେ ଓ ସାକ୍ଷୀମାନଙ୍କ ସାମ୍ନାରେ କ'ଣ ସବୁ ଲେଖାଲେଖି କଲେ। ମୁଁ ଦେଖିଲି ମୋର ଝିଅ ସମ୍ପୂର୍ଣ୍ଣ ପୋଡ଼ି କଳା ପଡ଼ିଯାଇଥାଏ। ପୋଲିସକୁ ସେମାନେ ମୋର ଝିଅର ଗରମ ପାଣି ହେଉଥିବା ସମୟରେ ଆକସ୍ମିକ ନିଆଁରେ ପୋଡ଼ିଯାଇଥିବା କଥା କହୁଥିଲେ। ମୃତ୍ୟୁର କୌଣସି ସନ୍ଦେହ ନାହିଁ ବୋଲି ସାକ୍ଷୀମାନଙ୍କ ସହ ମୁଁ ବି ପୋଲିସ ପାଖରେ ଲେଖିଥିଲି ଓ ଅନ୍ୟ ଏକ କାଗଜରେ ଲେଖି ଜଣାଇ ଦେଇଥିଲି। ପୋଲିସ ଆମକୁ ଶବ ଦାଖଲ ଦେବାରୁ ଶବକୁ ଧରି ଗାଡ଼ିରେ ଲାଠୋର ଆସିଥିଲୁ। ଆମର କଥା ଅନୁସାରେ ଲାଠୋରର ଶବ ଦାହ କରାଯାଇଥିଲା। ମୁଁ ମୋର ସଢୁ ଅନ୍ୟମାନେ ସେତେବେଳେ ଉପସ୍ଥିତ ଥିଲୁ। ତାପରେ ଗାଧୁଆ ପାଧୁଆ ସାରି ମୋର ସଢୁ ଘରେ ନାସ୍ତା କରି ଦିନ 4ଟା ବେଳକୁ ମୋ ଗାଡ଼ିରେ ଗାଁକୁ ବାହାରିଲି। ପରଦିନ ପୁଅମାନଙ୍କୁ ଡକାଇ
This statement is dated?
that is in the PS case, my lord.
PSK is dated?
Dated,
That must be after 2 months.
my lord, 15/3/92.
2 months. 15?
3 was
392.
53, huh? 3 months.
More than 2 months. About 2 months.
15/1 death.
2 months. That is what the IO also says, that I have recorded the statement.
My lord.
And there also there is nothing very.
Besides that, these questions have not been put to
That's there. 313 it was not.
my lord.
Yes.
And my lord, also what
Can you give me that translated copy of that? So that
Odia version is there.
I'll
Translate it.
I'll
My lord.
extract that.
And the IO has also stated, my lord, in conclusion of the investigation, I was also verifying that he says that because considering the statement like this, my lord, for which charge sheet was not submitted under 304B. IO says on 12/7/89, this is so and so married.
PW? IO is PW for.
Withdrawal 6 and 7 in the
She sustained severe burn injuries due to accidental fire cut to her wearing apparels and succumbed to the injuries while undergoing treatment, so and so, for which charge sheet was submitted only under 498A.
page 44, your lord. Withdrawal 6.
I submitted charge sheet 498 and not para 3 also he
Valid.
says at the end.
Para 3.
498A IPC and not under section 304.
4B.
That's also it says. Because of these statements.
Because of the statement. And the investigation in that aspect.
But if these statements are believed in 498A is also not made out.
It's
There
not
is no torture, nothing.
not made out.
Why has he done for 498A? ମାନେ କିଛି ଗୋଟେ କରିବାକୁ ପଡିବ ସେଇଥିପାଇଁ. If that is to be believed, then the entire case goes.
So page 42 PW 5 para 3 ରେ ସେ କହିଛି I had to write down the statement on the detection of the police. The exhibit A is the
Statement
step.
he ଦେଖିନି, ସେ
And
once
the doctor also says in the, replying to the question number 4, whether there was any smell of petrol and kerosene from
Nothing
the
is
body of the patient. At the time of admission, there was no smell of kerosene or petrol.
exhibit that has been
From the body.
exhibited as exhibit 3.
That is exhibit 3.
Madam. Question number 4, whether there is
Question number
any
4.
smell of petrol
Question number 4. This is also
If
there.
there would have been any substance in like that way, that would have spread.
Ah. All these things are creating doubt.
My lord.
But in question number 7, he says that it's homicidal death.
Not.
Burn can be possible by accident burning, and if not, whether it may be, your question cannot be answered in a simple manner. Okay. Then he is not definite about it.
Definitely.
Okay. It's all right.
I have given a written statement note and also memo of citation.
But the translation,
My lord?
translation.
And translation. Also, I'll do it today. It's
Okay. Then along with translation, you
Madam.
give it. And matter was while dictating the judgment, certain doubts insofar as the exhibit A is concerned has come to the court.
On confusion, my lord, I have not translated it because I could not do it because
No, I need exhibit A.
Exhibit A, which is that exhibit A? Because I was verifying from the record.
No, we did statement on 16-1.
That will be exhibit.
That is obviously because in the UD case it is.
Right.
UD case was registered on 15.
15.
So
But that was
16 is the UD.
very first statement.
No.
Right.
That's therefore, because see, the subsequent statement is on March,
Right.
15 March, that stands corroborated with the evidence of
Right.
IO,
Right.
who says that I recorded the statement after 2 months, exact
Right.
2 months, 15-3.
Right.
So therefore, obviously that must be the exhibit A.
Right.
Exhibit A. Therefore, the matter was again listed in the category of mentioned. The argument, the matter is heard, further heard, and
With that hope,
translated copy of the exhibit
with that hope, my lord, in the note I have mentioned that is exhibit A.
A. That must be the exhibit A. There is
I have
no-
stated, so it is pertinent to mention here,
Hmm.
the statement of PW5 recorded under section 161 of the code during inquiry of UD case number 1 of 92 on 16/1/92 within bracket wrongly referred in the judgment as writing of PW5
Right.
has been marked as exhibit A during trial on the reason of the statement.
Now, the interesting thing is you agree, I agree, and the prosecutor doesn't have to say anything.
He
So
has
then
not,
it
he has
is-
not seen that statement.
Deemed to be agreed.
Deemed to be agreed.
So regarding that exhibit A, there is in PW5, the page 42, written that on the
Both of them
recorded statement.
Oh.
Only one line is there.
But
That-
see,
I had-
the FIR was registered after 3 days, that
Yes.
19th.
Yes.
Incident happened on 15th.
Yes.
19th FIR was registered.
Hmm.
And this witness, which was strongly relied upon by trial court, this witness statement is recorded after 2 months by the
2
IO.
months, yes, sir.
And the IO says that from the record, he was satisfied that 304B is not made out. So therefore, 498 only I filed. But conviction is otherwise.
Right.
So therefore, all these things are creating little doubt.
Right.
And the benefit of doubt only if we have to give.
Yes, that-
Yes. Hmm? But all of you are there? Yes. Reports. First report, I'll take the reports. First report. The report starts from 15 onwards. Tell me the reports only. Let us see.
The other item 2 and 4.
2 and 4 want to argue?
I'll do it. It's a ballot case which can be ballot can dispose of. Basing upon ballot may see, it's a case of conviction on 306. But ballot may see the statement, if accused statement.
Then,
It's
turn it up
so
for review.
cryptic one. It cannot be conceived in the wildest imagination that case can. The purport of recording 313 has been frustrated. Criminal Appeal 35.
Really?
You know, 30
This
pages.
can be disposed of on this score itself.
Yes. Where is 313? Let us see. 313. Item two.
Statement of the
Two,
accused.
two.
This.
How many accused here?
Two ballot.
2 of them.
Ballot.
Okay. That is Malathi and Manmat.
Thank you.
Kailas has been acquitted.
Hmm?
One accused,
No, how many of them are put to trial?
3.
Trial 3.
Three of them. Kailas have been acquitted. And Manmat must be husband.
My lord.
Yes.
And who is Malati? Malati must be the mother-in-law.
Mother.
Mother-in-law. Both of them are convicted.
My lord.
For 306.
No.
The 304B 7 years and 306 2 years.
304B is also there.
My lord. 304 7 years.
Yes.
3 months for 498A. एते साखी एते कथा my lord may see page 34 of the brief.
44, yes.
And again, this sort of practice has been deprecated by the apex court and by this court also in many cases.
6 questions.
34, 3 questions, madam, only.
No, next 35.
35 person has been acquitted.
No.
No,
Continue.
36 questions.
देखो again.
Okay.
6 questions, madam.
What kind of questions? For
किच्छी नहीं. So why PWs are deposing against you? This question has been put.
କାମ ଜଲ୍ଦି ସରିଛି।
काम जल्दी से Rather, it has been this 313 has been developed to the extent that each question is to be put specifically.
Each question and each witness what they have said.
3, 4, 5, 6, 7, they have stated so.
It can't be like that. All the witnesses
It's not
have
an
said
empty
against you.
formality, my lord.
Question number 1 ନା ସବୁ question number 1.
Every incriminating evidence has to be put to the
Valid.
accused.
If that will be relied upon against me.
Question number 1 ନା ସବୁ PWR ଏକାଥରେ ଲେଖି ଦେଇଛନ୍ତି।
But what is the question number 1? Read it.
It
We transfer from the evidence of PWR.
Huh.
Consider
All the witnesses name, so and so,
that is
that in the year 1990, you married to the deceased Surama, as per the as such the gold necklace and cash, etc. So and so. If the convictions are done like this, then there is no end. Which witness has said what? What was the demand? Nothing is there.
It's true, Your Honor. Even I saw that restaurant.
The last question number 6, just see.
Question 6.
Micho case Kori Santi.
ଆଜ୍ଞା।
ଆମ୍ଭ
ଆମ
ଘରେ
ଘରେ ସୁରମା
ସୁରମା
ଚଳି ପାରୁନଥିଲା ସବୁବେଳେ ବାପ ଘରେ ରହୁଥିଲା କାରଣ ସେ ଧନୀ ଘରର ଝିଅ that has come up during
how she died?
well committed suicide by taking that oleander sheets kanyare bhanji.
Is there any evidence that you have any of you
No,
have
no.
administrated it? Where is that evidence? Because 306 means committed suicide only.
My lord, may see this evidence of the doctor.
Yes. PW?
That is, my lord, 6 at page 61.
Yes.
No external injury, nothing else. In fact, my lord, there was a complex that why I was given marriage to a family where nothing is there. And
Maybe frustrated. See, these
Frustrated,
relationships are very
my
complicated.
lord. Yeah, so that has been put to the witnesses also.
The final opinion is pending chemical analysis of the viscera. Since the time the death is within 24 hours. Viscera report is there?
My lord.
What does it say?
Organochloroinsecticide poison could be detected in the viscera described above.
It is poisoning. There is
That
no,
is no question in that aspect.
there is no external injury in the body of the deceased.
No extent.
No, it is. Cross-examination, there is no external injury noticed in the body of the deceased. There may or may not be injury if the poison is administered forcibly to a person.
Okay.
He କହିଲା ଯେ ଦେଖିଲା ଯେ postpone, how can it be presumed?
These are hypothetical questions and not. And who is the informant? What does he say? Doctor is PW6, na?
Well,
Doctor is Pedals.
PW6. And that PW6 evidence is also not put to the witness.
no one. After perusal of the accused, I thought nothing can be argued in this case in view of 2009 Supreme Court and 2024 Supreme Court. While it means the judgment of Hon'Ble Apex Court in 2024, that it goes root to the case and nothing
Yes,
can
that's
be
there, that's there. That's the fundamental.
violent.
Who is the informant? Let us see.
PW5. Informant is PW4.
4. Let us see.
Sibo Sankar,
Is the brother. Who is it?
brother of the deceased. Sibo Sankar are the
No.
co-villagers of the. I think informant is.
Let us see. What?
Affair is 27. Assumptions of that matter. PW5, 55 matter.
Yes, I'm there. See, page 51, if you see in the middle,
Well,
in the meeting, the accused persons told that the deceased was threatening to take poison.
well.
So the
Time and again,
question
madam,
is
that
to
is-
make- to consider the fact. Thereafter, the father of the deceased told that the father of the deceased also told that they would give consolation to his daughter, so that she would not take poison. Their financial condition was not too good.
Yes, that
In spite
admitted.
of knowing the such financial conditions, the accused, the informant gave marriage to his daughter in the family of the accused persons. Not anything about the disease regarding the consent.
That's sued or to commit suicide. That language has been used by Ladvi in 84 Supreme Court, 1622, which I must have used number of times, Sarad Bhaichand versus State of Maharashtra. That is in a case of dowry death. The language used by Justice Fajr, that long cherished desire to, that leads to this.
That it appears to be a case of non-cherished
Yes.
desire. Page 53 is
My lord.
the deceased did not complain before me regarding ill treatment of the accused persons towards her for the dowry articles. I usually stay in the village. I did not hear any complaint from the Sahi people regarding the ill treatment of the accused persons towards the deceased. Now I am pulling on well with the family of my Sadu. I did not ask deceased regarding her adjustment in the family of the accused under the petition.
ଏତେ କଥା ଏତେ ବଡ ବଡ ଷ୍ଟେଟମେଣ୍ଟ କୋର୍ଟରେ କିନ୍ତୁ ଗୋଟିଏ ଲାଇନ ମାନେ କ୍ରସ 330 ତିନିଟା
There the whole difficulty is. The evidences are very extensive evidences, and nothing was put to the accused.
ଦିଟା
330.
କ୍ୱେଶ୍ଚନ
See, 5 pages cross-examination. So many things has come.
ବଟ୍
In evidence, so many things has come. Then what do you say? Shall I proceed with this, or you will get some judgment contrary to the judgment which he is citing?
Latest judgment matter I have given 2025. Oh, what
Read the
contradiction.
judgment. How will you get out of it? Tuesday. Partly heard Tuesday.
My lord.
Partly heard Tuesday. Come with the written note.
Yes, sir. Yes.
Part heard Tuesday. Yeah? Tuesday at the top. ठीक है. Please give that judgment so that he will
My lord.
verify if contrary judgment he can find.
September part Oceana report is. September part
The
Oceana.
sanctity of 313 is, the scheme of law is, whatever evidence is brought on record by the prosecution, everything which is to be used against the accused has to be put to the accused. And an opportunity is to be afforded to the accused to explain that. And then at the end, it is asked whether you want to lead your defense evidence. Then to substantiate whatever stand he takes, he says, yes, I'll lead or I'll not lead. Thereafter, defense evidences are laid.
See, that's all.
If you don't put any incriminating material
Yes,
to the accused under 313 statement, you can't use those evidences
My lord,
against.
may see, my lord,
This is
this,
the fundamental principle.
volume 98, 2025, OCR, page 330.
The many judgment you will get.
That is the latest one.
But the evidences are there. Not that evidences are not there. Evidences are there. But you have not put to the accused. 313. Whether those incriminating evidences can be used for the purpose of maintaining a conviction like this.
yes, sir.
If he has not been given an
The
opportunity
procedure is
to explain
vitiated
this.
completely. Completely. get some judgment so that on that light we can also elaborate judgment. That, yes. Period. Item 3,
My Lord, if I may do it.
Tuesday. Tuesday, come with all judgment and all. And written note also.
Yes, sir.
And convicted under section 20 of NDPS Act for a period of 3 years, my lord.
Hmm.
And the quantity of ganja is 2 kg 500 gram.
Yes, it is partly heard, it seems.
Yes, my lord. Yes, my lord. Last occasion, your lordship directed
2.5 kg of ganja.
Yes, my lord. On last occasion, your lordship directed to produce a judgment, my lord, relying upon section 50 of NDPS Act. It is mandatory.
Now, let us see the first fact. Let me recap the fact. What the
There are
PW1 is the
Independent witness.
independent witness. What
And
does
2 is the ASI of police, 3 is the SI of police, my lord. He is the informant, my lord. The investigating
what does
officer,
he say?
my lord.
What
He-
does he say?
He says, my lord, the consent has given for search and seizure, my lord.
There are other independent seizure witnesses, those who have been not examined.
Yes, my lord. 2 witnesses examined during investigation, and one was hit.
But
on
you have examined them as a defense.
defense witness, my lord.
What does he says in defense?
Page 66.
Case 66, my lord.
In DW
DW 3, my lord.
3. Yes. What does he say? Yes.
Page 66, your lordship.
Yes. Read it. I know
I
the
excited SI Bali said he told 3 about 3 to 4 years back. He took my signature on a written paper at Khurda in connection with a case. He had not read over and explained the contents of the paper, but told me that it was in connection with the case of Gonza.
sign exhibit.
I have signed on exhibit 5.
Five.
Signature is there and signature is admitted the signature also. At the instant of Pirol 3 and profile. That's how is no signature there. It is not the fact.
He admits the signature, but he says that it was obtained from me without disclosing.
Yes, my lord.
Even that but told me that it was in connection with the case of Gonza. That means he knows about this. What he is signing over. Just now he is now saying that it is on the instance of the police. I am on the instance of the Pirol 3. I am signing over it in a written paper.
Hmm.
Even in the admit that it was in connection with the case of Gonza. He also the witness. So bote witness
Which ganja? Which
case
ganja?
of
Ganja throughout India there is ganja cases. In which case?
no.
You say that it's ganja case, so sign it. He has signed it. How will you relate with this case? Does he say that it is regarding the recovery of 2.5 kg from so and so? Sign it. It is related to some ganja case.
Even he admitted about the signature. In that signature, it is written over.
That is why he explains that.
Yes, sir.
He explains. Why have you not examined him? It is your witness.
Yes, sir.
Who is the witness who is
Here, page 16 is the observation case.
page 16?
Page 16.
16.
Second part.
16 running page?
Running page, yes, sir.
Yes.
No doubt,
No doubt.
other constituents, namely Prabhas Kumar Das,
Hmm.
Prabhas Kumar
DW3.
DW3 has stated that he has given the signature exhibit 582 on the signature list. Exhibit 5 at Khurda without witnessing the search and seizure. But this evidence of DW3 ipso facto does not set the cognizant evidence of the PDL 1, 2, and 3 at naught. In this case, Dilip Pandurang Kolekar versus State of Maharashtra in the Division Bench of Bombay High Court observed in thus.
Read that Pandura's speak. What does it?
The sponsors admit their signature on the exhibit 10 and we see no reason to believe their version about being made to give their signature to a document. The contents swear do not reflect what had taken place in their presence. A contemporaneous drawn of exhibit 10 suffice to corroborate with the testimony of the head constable and the police constable. There is no rule of prudence, much less of law, that uncorroborated testimony of police witness should not be relied upon. In the present case, the evidence of the excise officer, PW 2 and 3, has been corroborated in material particular by one of the punch witnesses, namely PW 1.
Yes. Weight, who has taken the weight?
Wait, a police officer, PW 3.
Show me.
No, no, excise officer. PW.
Excise officer.
Weight was done.
Yes, my lord.
Yes,
He was carrying the machine also.
making up.
Right.
Most interesting, my lord, PW1, my lord, the independent witness. In a later stage, my lord, he has declined. No such seizure has been made. PW1, my lord, page 47. On re-examination, I wrongly identified the plastic bag in CM number 39 of 99 as the bag containing ganja. Due to inadvertently, amount number was the plastic bag containing ganja, such and so, now shown to me is the material object, which was seized from the
Yes, how do you deal with this?
Now show me, not show me. Now
Huh?
show me. Show me to be is the material object which was seized from the accused person.
Re-examination, page 47. I have wrongly identified the plastic bag.
It is not a fact that any two was not seized from the accused person.
Faster,
Re-examination.
re-examination. On recall data.
Plastic bag containing ganja. First examination. It is not a fact that I have
Deposed.
false last name. Wrongly identified the MO1 which was seized in other case. It is not a fact that MO2 was not seized from the accused persons.
What is that evidentiary value?
The question now.
Stage to stage, he is changing her version, his version. That is your witness. Prosecution witness.
Re-examination upon actual setup.
Time to time he used to change it. What is the evidentiary value of that person?
PW1 was a constable, huh?
No, my lord. PW1 is the independent witness.
Independently.
Independent. PW2 is the constable.
ASI of police. my lord.
ASI.
My lord.
ASI, yes.
He was the
ASI.
raiding party. my lord.
They were riding cycle or Luna?
Cycle. A Luna, my lord.
Luna.
In a Luna. And seizure, place of occurrence, my lord, just 200 meters from the Khorda bus stop, my lord. And no independent
his
witness. Yes, my lord.
Almost how Lakshmi
430.
riding Luna. Chemical examination report is there on record.
Yes, my lord. Exhibit 9.
The same day the sample was produced before the special,
My lord.
that special judge, huh? 5/12/1998. But PW2, see, PW2 and 3 are very meticulous
My lord.
in their evidence.
That is true, my lord, but section 50 has not been complied with. Either before executive magistrate or any gazetted officer. In absence to that, my lord, they have to comply to.
Then that is your only case.
Yes, my lord.
That,
Two independent witnesses to be.
For this, that page
produced.
16, that observation is very much clear.
And
No, he is relying upon the
And the
judgment. Which
judgment of
paragraph?
Honorable
Their
Apex Court is
lordships
very
have
much
said
clear, my
that
lord.
the
That is mandatory
and
section 50
requirement of
compliance.
section 50 and which is mentioned. The provision of section 50 must be strictly complied.
Yes, my lord.
even in 3-1, that accused statement of see.
Page 23, my lord. That is relevant paragraph. The Arif Khan judgment, my lord. Last time
Which paragraph is helping you?
paragraph 23, my lord.
20?
3, my lord.
Read it. Which part?
Their lordship have held in BJ Chandra Jadeja that the requirement of section 50 of NDPS Act are mandatory and therefore the provision of section 50 must be strictly complied with. It is held that it is imperative on the part of the police officer to apprise the person intent to be searched of his right under section 50 to be searched only before a gazetted officer or a magistrate. It is held that it is equally mandatory on the part of the authorized officer to make suspect aware of existence of right to be searched before a gazetted officer.
This has been done in this case.
Yes, my lord.
Yes. Or a magistrate. And if so required by read it.
Simply consent is not sufficient, my lord. If consent is sufficient, then he has to bring two independent witness, my lord.
Read
per
it,
section
read it, because
My lord.
this requires a strict
If so required him, and this require a strict compliance. It is ruled out that the suspected person may or may not choose to exercise the right provided to him under section 50 of NDPS Act. But so far as the officer is concerned, an obligation is cast upon under him section 50 of the NDPS Act to apprise the suspect of his right to be searched before gazetted officer or magistrate.
Yes.
Keeping in view of the aforementioned principle of law laid down by this court, we have to examine the question arising in this case as to whether the prosecution followed the mandatory procedure prescribed under section 50 of NDPS Act while making search and recovery of the contraband charas from the appellant, and if so, whether it was done in presence of a magistrate or gazetted officer so as to make search and recovery of contraband charas from appellant in conformity with the requirement of section 50. In our considered view, the evidence adduced by the prosecution neither suggested nor proved that the search and recovery was made from the appellant in presence of either magistrate or a gazetted officer. That is vital, man. And next paragraph. It is the case of the prosecution and which found accepted by the two courts below that since the appellant accused was apprised of his right to be searched in presence of either magistrate or a gazetted officer, but despite telling him about his legal right available to him under section 50 in relation to the search, the appellant accused gave his consent in writing to be searched by the police official raiding party. The two courts below came to conclusion that the requirement of section 50 stood fully complied with, and hence the appellant was liable to be convicted for the offense punishable under the NDPS Act. We do not agree to this finding of this two court below, as in our opinion, a search recovery made from appellant of alleged contraband charas does not satisfy the mandatory requirement of section 50 as held by this court in Vijay Chotha Jadeja. This is a way for following reason. First, it is an admitted fact emerging from the record of the case that the appellant was not produced before any magistrate or gazetted officer. Second, it is also an admitted fact that due to aforementioned first reason, the search and recovery of contraband charas was not
made from the appellant in the presence of magistrate also. Thirdly, it is
from the
also
appellant
an
in presence of
admitted
magistrate or
fact that
gazetted
none
officer.
of the police officials and raiding party who recovered the contraband charas from him was the gazetted officer, and nor they would be, and therefore they were not empowered to make such recovery of the appellant of so and so contraband. Section 50, except in the presence of the magistrate, so and so. Search and recovery of the contraband articles from the body of the suspect, recovery to be conformity to the requirements of 50 of the Act, and it is therefore mandatory for the prosecution to prove that such a recovery was made in the presence of magistrate also. Yes. Have you taken written consent? Written consent is must. That is, it was apprised to him, and he said that you can proceed.
Yes, sir.
Are you? Show me the IU statement.
Yes.
The requirement is it has to be done in presence of magistrate and gazetted officer. But if the accused is apprised of this fact, and if he says that yes, you can proceed without the executive magistrate or but that has to be given in writing consent. Where is that? Then that 50 is complied.
Exactly.
Who is the IU?
PW3.
PW?
3.
3. Read PW.
I was posted as excise SI.
Read relevant part.
Page 54, in the presence of the witness, I informed
54.
54.
Right on. In presence of the witnesses,
Yes, sir.
I informed the accused
Accused persons
that
to be searched in presence where the magistrate or gazetted officer of any designated department. I served a notice on them to
exercising
exercise
their
their efficient
officer
of under 50 under 50 of NDPS Act.
with the copy
Exhibit 1 is the copy of the notice I served to accused Lakshmindra Vera, and 2 is the copy of the notice I have served to accused Manoj Sahu. Exhibit 1/3 is my signature, and exhibit 1/3 signature. Lakshmindra Vera there on exhibit 2/3 is my exhibit 2/3 is my signature. Exhibit 2/4 is the signature of the accused Manoj there.
voluntarily
Both the accused voluntarily
consented
consented. Yes, sir.
by me,
By me,
and also gave the consent in writing.
Right.
Exhibit 3 consent is there. Show me the exhibit 3.
3/1.
50 is complied.
Yes, sir.
50, my lord, but in presence of two witness, my lord, that has to be. The consent has to be taken in presence of two witnesses.
Page 26, Your Worship. Written consent of the accused
As
L.
per
Mehra,
section 50, my lord.
But
consent of the accused M.K. sir.
okay, but what he says is you have complied, then no problem. But even the consent
Yes, ma'am.
which is obtained in Exhibit 3, that has to be done in presence of two witnesses. Where are the two witnesses?
By following section 104 of CRPC.
Because 104 says
Thank you.
two witnesses are required. You have procured two witnesses, but not examined.
But not examined.
You have examined one, and you left the other one. So therefore, 50 is not complied. That's what he says.
For this also, I am page 16 to say observation.
No, but you have to come out that. See, section 50 requires what? Three things.
Yes, sir.
It has to be done before the executive magistrate or gazetted officer. If no executive magistrate gazetted officer available, you have to procure two independent witnesses and tell them that asking permission to them for the purpose of search in the absence of gazetted officer or this thing. And these two witnesses, written consent has to be taken in presence of these two witnesses. You have done everything. But the presence of the two witnesses is not there. He reads the section, where is that section? Oh,
Section 50 appending this.
section 50. 50, huh?
Thank you.
Love. What do we get? Read 50.
Section 50 subpara 5, my lord.
50.
Yes. When an officer duly authorized under section 42 has reason to believe that it is not possible to take person to be searched to the nearest gazetted officer or magistrate without the possibility of the person to be searched. Possession of any narcotic or psychotropic substance or controlled substance or article document
Five,
he may
five.
insisted of taking such person to the nearest gazetted officer or magistrate proceeded to the search person provided under section 100 of CRPC.
100 out here. 100 says that two witnesses are required. There you are stuck. Shut up. The first part of the appeal is so and so. Mr. Mr. counsel for the appellant submits that in the present case the mandatory provision under section 50 of the NDPS Act has not been complied. He has emphasized section 50 clause 5 with this agenda. He further submits that in the present case, although the procedure contained under section 50 has been complied partially, but this has not been done in presence of two independent witnesses. Perusal of the evidence brought on record by the prosecution reveals that two independent witnesses, those reveals that the perusal of the evidence of PW3 reveals that he has
You also
sets he has he is the alleged contraband from the accused persons by taking a written giving a written notice under Exhibit 2 that the gazetted officer or the magistrate is not available, and seeking express written consent from them to search and seize the article from them. The written consent was also obtained from the accused person by the Exhibit 3. Exhibit 3. Thereafter, the search was carried out. Mr. Das, learned counsel for the state, submits that since the written consent was obtained from the accused persons, while exhibit 3, the compliance of section 15 is satisfied. However, it is apparent from the record that although the written consent was taken, but in not in, taken, however, the same was not done in presence of two independent witnesses. In the present case, the statement of the evidence of PW 3 in that regard is relevant, which is reproduced. 54 reproduce CORAM. From the prosecution evidence, it is further germane that when the appellants were intercepted, two persons, namely namely Balakishore Shetty, PW1, and other from Khurda, namely other Prabhat Kumar Das, were passing through the place of occurrence. They were roped in by the roped in by the IO to be the independent witnesses. PW1 was examined by the prosecution. The evidence of PW1 is somehow shaky. However, however, the other witness, namely Prabhat Kumar Das, was not even attempted to be examined by the prosecution. On the contrary, the defense has examined the said witness who has deposed as under para 166, para 166, para 166. In the light of the aforementioned judgment, Mr. Mishra submits that the prosecution, although named two independent witnesses, namely PW1 and Prabhat Kumar and DW1, however, DW1, but deliberately did not examine the second witness. So, in the absence of the deposition, absence of the evidence of the two independent witnesses, the requirement under section 100, as occurring in section 50 bracket 5 of NDPS Act is not complied. In that view of the matter, he seeks an acquittal. And he has relied upon the judgment reported in so and and the paragraph so. Section 100 भी करवा, ठीक है? No.
Lord, sir, I'll take page 54 तक. Page 50.
Yes, what do you want? Yes.
Page 50 is regarding the under section 50 that complaint said both the accused voluntarily consented to be searched by me and also gave.
But you have not examined
and also gave the consent
they
writing.
have done it, but they come to the witness box.
Yes.
Have they come to the witness box? Both of them. PW1 has come. His statement is a little shaky, and the other witness you have not examined at all.
Not other the witness of the PW2, the police officer as the witness in this case.
See, this draconian law, the procedure has to be complied very strictly.
That amounts to the
100 is, section 100 has to be complied. Read with section 50 bracket 5. Okay.
And
If you want to have any judgment, you can give. I can change my view. No problem.
Right.
If you can. Yes.
And relying upon the constitutional
Okay,
judgment.
next. Okay, we'll see.
More reports.
Yes. 4.
Should be passed over.
Pass over. Okay. 5.
May I please?
Yes.
I have prepared a small note. the data. The
They,
Today, everybody is arguing.
sir,
Sometimes nobody is there.
okay, have another.
Yes.
the appellants are convicted under section 325, which is 1 year and 500 fine, and for 323 it is 1 month, 500 fine.
Yes.
In default 1 month. Initially, the FI registered under section 341, 294, 223, 225, 34. When the charge was paid, one also P1 X of SCST Act was added 1 month. But they were acquitted from all the charges and convicted under section 325 and 326. One of the genesis of the FI is one of the facts of the cases like that. One of the accused, the victim, who was PW3 and PW4. Well, these to the daily
PW3 and 4 are the injured witness.
Injured, yes.
Okay. PW, injured witness, PW3 and PW,
4 is also injured and the 4 is
was
the
the
informant.
informant injured.
Yes, sir.
And
Ticket punching
daily
on the
market
card.
purchasing the two appellants approached them and they asked them why you are purchasing goods and assaulted them. First, from the FIR, it shows that accused person assaulted was the PW3 who sustained bleeding injury on his head, and subsequently he ran away. And they, when the PW4 protested, he was assaulted. There is only PW4 was medical examined by the PW
But
10 malus. And PW3 was not examined.
PW3 not examined.
Not examined. Not
PW3
examined.
not examined by doctor. No. By doctor. PW4 examined
By the PW10 is the doctor.
by PW10, huh?
The
Yes.
FIR is registered on 31st July 2001. And the incident is the previous date, my lords.
30th.
30th July 2001.
Okay.
The as per may I read the PW4 first, my lords.
Yes. PW4.
My name is such and such, and I'm reading the relevant parameters. One Jagabandhu Pangi was the assault accompanied me. He was going there on me. The accused person were abusing Jagannath Pangi. Now, there are two names, Jagabandhu and Jagannath. Maybe
You are Tilok Khoda and what is your name? Tilok Khoda and
Shyam Sundar Padal.
Shyam Sundar. Second one is Shyam Sundar, huh?
Yes, ma'am. The accused person were abusing Jagannath Pangi as such and such. They assaulted him with lathi and chain. As this weapon of assault has not been seized. The prosecution, lathi and chain. When I protested them, leaving Jagannath Pangi, they assaulted me by means of iron chain, lathi to my head. Due to my raising of hands, the lathi assault fall on my hand. I sustained.
Where these accused persons were
PW4.
using Jagannath Pangi and so and so, and they were assaulted with the lathi, eh? With lathi.
Lathi and chain, iron chain.
Iron chain. Not recovered.
Not recovered.
Yes.
They assaulted me by means of iron chain to my head. Due to raising of hands, the lathi assault fall on my hand. I sustained injury on my left hand. But the medical examination shows there is no injury on the left hand. And the right hand on palm portion as well as gut injuries. The weapon of assault is lathi and chain. And there is a cut injury where the PW4 is reposing. And on parts of my body due to assault.
Yes. Yes.
Such assault, I sustained injuries. Such and such that I am Dumbo by cast. They abused me. My hand was fractured. Ganesh Kilo, who is the PW1? Well, he's turned hostile. Had seen this occurrence. Apparao reached the spot afterwards. He has not examined. Apparao was not examined. After this occurrence, I lost FIR in the police station. Once tried.
scribed the FIR as per my statement, and I affixed my LTI because of the injuries sustained on my hand. I could not write FIR with my hand, but I know reading and writing. Exhibit 1 is the said FIR. Police Babu sent me for medical examination to district hospital, Koraput, where X-ray to my injured part was conducted. I also affixed my LTI on the medical examination report and requisitions. In the cross-examination value, the first line itself, the FIR was scribed by the police inspector as per my statement. In the previous paragraph, he's deposed.
Somebody else has done.
Somebody else has done.
Yes.
Whereas, your lordship, see the IO, who is the OIC, my lords.
Joseph, intuition says that one scribe, not somebody else.
One scribe, my lords. PW9, my lords. But in the cross-examination, he deposed that was scribed by police inspector. My lord, PW.
But the existence of the FIR is not doubted. We scribed is a minor discrepancy.
It is
From the evidence, the only thing which you can highlight is the weapon of offense is not recovered.
my lords,
That's
there
right.
are other contradictions. my lords.
And the injuries which is stated by him to have been sustained is not corroborated with PW10.
Corroborate with the PW10. But my lords, PW10 examined the victims on 30th at 9:35 p.m.
Yes.
The FIR was registered on 31st.
Next day. Yes.
9 a.m.
Yes.
And he himself deposed after Police Babu sent me for medical examination. But my lord, the PW11,
Exhibit 1 is the said FIR. The police babu sent me for medical examination
Yes,
to
of course.
district hospital, Koraput, where the X-ray was certain. Also affixed. Yes. Yes.
and kindly see the PW11 paragraph 2 minutes.
PW?
11. Who is the first IO of the case?
Yes.
On 31st/7/2001, I was the ASI police attached to the Fatwa PS on such and such date. And they directed me to took up the investigation. During the course of investigation, I went to the hospital where injured was admitted. He have requisition for his medical examination. Whereas the PW4 statement says the police babu sent for the medical examination. And the medical examination report itself says as page 90 minutes of the TCR. It shows that the medical examination was done on 30th/7/2001.
Yes.
And Lord, if I read my Lord PW3, who happens to be eyewitness, but my Lord, he has not actually seen the occurrence, as he himself said.
Who? PW?
3 my lords. The
3.
injured, another injured.
Yes.
Now, paragraph 2 I am reading. This occurrence took place about 4 years at 3 p.m. at noon. I and Sudev Pangi has gone to Rising Heart of purchase boat. While we were bargaining to purchase boat, accused Tilota Khora assaulted me on my head with a lathi causing bleeding injury. He also accused me in option words such and such. So out of fear, I ran away. My lords, when the appellants assaulted him, he ran away, my lords. He actually not seen the offense on the PW4. And there are no other eyewitness. There is a marketplace. And there is a daily market on that day, my lords. PW1 and 2 who happens to be the eyewitness, they turned us dead.
What was the motive of?
My lords, that has not been explained by the.
There was past enmity, anything was there?
No, my lords.
Yes.
And the my lord, injury, my lords, for
PW10 injury.
case 90, my lords. The injury number 1 is simple in nature and the occurrence.
The lacerated injury. Site perception. So
Maybe within the second injury, who is the
injury number 2 is grievous.
grievous, maybe within the 7 days. But the occurrence took place at 2 p.m. If you consider the examination at 9:35 p.m. which is merely around 7 hours. The doctor opined that the injury is of 7 days, my lords. It can
Where
happen.
does it say?
After the episode came to conclusion, injury number 1 is simple in nature.
And that is a deposition, man.
The age of the injury was within 24 hours.
What was the second injury, my lords? The page 90 may on the candidacy of the visa.
Which para? Which paragraph? Injury report.
Injury.
Exhibit? Which exhibit is that?
Page 90 of the visa.
No, exhibit you tell me. Exhibit 9 over 9. 9 over 2. Exhibit 9. Exhibit 9 over.
Page 91. Injury number 2 is the grievous in nature, may be caused by hard and blunt objects, may be within the 7 days of duration.
Maybe within 7 days.
7. My lord. PW10. PW10 is
24 hours is also coming within 7 days.
PW10.
Has it been, if you would have said that it is within the expression used within is creating problem.
Maybe, my lords. Always the benefit of doubt leans with the
Leans to the accused.
accused.
Yes.
And paragraph 5, my lord, it says injury number 2 is possible by fall on hard and blunt object, my lord.
What does it say?
PW10, paragraph 5, which cross examination.
Aim is 5, huh?
Yes.
Possible by fall on a hard and blunt surface. Yes. You have been convicted with 325,
Both 325, 323.
23. If injury number 2, I will not believe it will be 323.
320.
That's your attempt.
323 also not with established, my lord. Because only there is a
But 323, what was the sentence?
500 fine.
325 or 1 year.
Incident had taken place when?
2001, my lord. They have already went
25 days they have already undergone. Yes, what do you say?
You know, so, kindly say, as it's, as the complaint of the cross examination, where injury is possible by the possible.
See, he has created a doubt insofar as injury number 2 is concerned. Created a doubt. If injury number 2 is not to be believed, then it will be a case of 323 only. 325, he can be acquitted.
So say that it will be 24 hours. In 7 days, will within the 7 days also.
See, when the deposition is, he has deposed, you tell me. He deposes, date, just see the date. 2016, 2006. Okay. 2006, he deposits. And exhibit 9, just see exhibit 9 the same day. Which would have more?
That's about the difference between the 7 days and 1 day. Even the 7 days, within the 7 days, 24 hours.
That I am right, but you try just see the exhibit 9. Exhibit 9 is very clear on the same day. This is the uninfluential version of the doctor.
So if the fracture is a grievous injury, if the fracture is before the occurrence, then ଯାହାହେଲେ ବି ତ bandage ଫ୍ୟାଣ୍ଡେଜ କରିଥିବ ନା ଖାଲି ବୁଲୁଥିବ ସାର ଗୋଟେ fracture ଲୋକଟା
No, you see the evidence. Don't.
ସେ ଆସିଲା ନା ଗୋଟେ ଦିନ ଭିତରେ ହେଲା ସେ within 7 days.
It will be considered.
But it may cause due to fall also. See, showing that
Possible, maybe.
possible. There are two things
fracture-
where injury number 2 can be doubted.
Fracture ଟା କେମିତି ପଡିଲେ ବି fracture ବି ମାଇଲେ ଗୋଟେ ବାଡିରେ ଦୁମକି ଗୋଟେ fracture ହେଇଯିବ possible ସେଟା ହେଇପାରିବ ପଡିବ.
The position of
That's
the
a possible
PW4 is inconsistent, man.
The possible way
The
of
position of the PW4 is inconsistent. He is telling that he got the injured.
fracture anything
Left hand.
fall down
But in
fracture
case-
ହେଇଯିବ.
Yes.
ଆଉ ସବୁବେଳେ ସେଟା possible ହିଁ ରହିପାରିବ.
Oh, 313, if you see, question number 13, very specific question, 12 and 13.
They have lost the FIR because there is a.
It is also suggested to you, you have not said anything. It is also transferred from the evidence that the injuries could have been caused within 24 hours of his examination and by hard and blunt portion. What do you have to say? The 113 statement. Question number 13. 12 and 13. Evidence कर दो exhibit 9 करें.
Got any injury, my lord, how these appellate with criminal go? That's why he deposed more guarantee.
What page question number 16 just see. উপবন্ধু
Hello.
what have you said?
ମୋର କପଡ଼ା ଦୋକାନରେ ଥିବା ଏଇ ଘାଟରେ ଖୋଲିବା ବେଳେ ଗଣ୍ଡଗୋଳ କଲେ ମୁଁ କହେ ତାଙ୍କ ନାଁରେ ତାଲା ଦେବି ବୋଲି ସେମାନେ ମୋର ଏବଂ ଶ୍ୟାମ ଟୋଟାଲ
Yes, anything else? Yes. Yes. Anything else? PW, this is PW4. All other contradiction which you are showing is very minor contradiction.
With E mallots, PW10 and PW4 mallots, the medical examination and the injuries as deposed by the victim who has been examined. Only there are two injuries. But my lord, in his deposition, he has deposed. He got injuries on the left hand. Other parts of the body. Got injuries in the on other parts of the body. There is no cut injury. There is
There are two witnesses, that is PW1 and PW2. Are hostile, huh? PW3 ran away after the assault.
Yes,
So he has not seen the assault on PW4. That's your case.
yes.
Even in the period one, the last thereafter took Supreme with me to Hon'Ble medical for medical treatment as he complained of pain in his hand due to fracture.
Hmm?
It was one page 22.
Yes.
This was last page.
Hmm?
Thereafter took Supreme with me to Hon'Ble medical for medical treatment as he complained of pain in his hand due to fracture.
Then the fracture has taken place there.
From that place, if we consider the deposition of the PW1, then one of PW4 says.
No, what he is trying to show is that the doctor says within 7 days.
Yes.
Then he says that this is recent, from the occurrence, this fracture has taken place. That's what he want to show.
My lord, it is because of the assault, my lord, nowhere it is said, my lord.
So that's what he
It
says.
may
See,
be
he was
for-
taking him to the hospital.
It may be
It was paining due to fracture. That's what he says. So that 7-day thing may not help you in view of PW1.
No denial. But by fall, it can happen, my lord. PW1 has not said anything that the appellants have assaulted.
No, the PW to that extent he has not said, but the only thing what he said is
Fracture.
fracture.
Within 24 hours.
Your argument that
7 days.
7 days things may not help you. Just see anything. Oh, we'll take it out. Huh? I'll just hear it. I'll just come. Mr. Ratha, you are waiting for which matter?
That gave an undertaking.
Yesterday it was there.
Yesterday.
Yes,
Day before yesterday.
day before yesterday it was there.
They gave an undertaking.
That I know, contempt. Mr. Acharya was appearing. He is there. Let us wait, he may come. Because there is a contempt petition also.
Yes,
you
yes,
filed.
please.
And yes. Exhibit 9. Yes, anything else?
This was who assaulted him, the injured.
Sorry?
Who assaulted him?
Huh.
That was not specifically said. There are two accused persons.
PW4.
PW. They
Let us see.
assaulted me.
Again, let us see PW4. Does he say anything? Accused persons. Okay, huh? They assaulted me.
PW3 says the accused persons also assaulted Sudepangi by means of lathi on his head. But PW4 is not saying that there is an assault on his head.
What PW3 says?
PW3 says who happens to be ran away by his own statement. My lord, towards PW3, my lord, paragraph 2, first page, my lord.
No, but
Third line.
PW3 specifically says,
Third line from the bottom.
Tirota Khora assaulted me
On my head.
on my head.
Causing bleeding injury. But he has
He
not,
also abused me, so and so, so and so. The fear, these accused persons also assaulted so and so.
he has not filed FIR. He
Yes.
has not been made medical examined. Nothing.
That's right, that's right. That's right. Not specified.
My lord, it is a marketplace, my lord. There are lot many independent witnesses, my lord, but none have been supported the case, my lord. And my lords, from the evidence of the PW4, it shows, my lords, he trying to falsely implicating the accused because he's telling beyond his injuries he sustained. And the main motive of the PW4 is to fall in the to make the appellants fall in the trap of SC/ST Act, which ultimately they have been acquitted, my lord.
Yes. With PW5?
PW5, my lord, is the seizure witness. And he has not supported, my lord. That is regarding to ROR, my lord. Every seizure of regarding the ROR.
Okay. Who is 6? Police constable. ROR.
ROR.
He is released. Yes.
7 is the witness to prove
7?
caste certificate.
Caste certificate. 8?
ROR seizure witness, my lord.
Seizure witness, huh?
Yes.
ROR, same ROR.
Yes.
It is neither in other. And who is 9?
9 is the voicing.
Voice. Yeah. Right, teach them. Where is 10 is the doctor, huh? Lacerated wound. 11?
11 is the first IU after.
First IU. Yes.
PW 11, cross-examination, paragraph 3, my lords, the second line. My jurisdiction disputes that the informant and the accused person were inimically disposed of.
That's
But whereas the appellants were not named in the FIR. It was an unknown, FIR against the unknown person.
and it is not or and I was thinking of fine, but yes. What can be done? Conclude. Judgment trigger. The injury number 2 is caused where? Lacerated wound? Which part of the body? Let's see once again.
It is usually over right.
Right hand. Right hand, huh? PW4, sorry, PW4 right hand. But PW4 says it is a hand. Yes, slowly. Left hand and right hand both. It stands corroborated, but that's the problem. Yes. Judgment trigger. Yes.
Item 6.
Here.
Order dated 10th July.
10th July. What happened? What modification? Huh?
For no instruction, the revision was dispensed. As no instruction. At page 9, annex of 3. Page 9, annex of 3. Annex of 3. Is it arising out of the proceeding under NIA?
I understand the appeal is also dismissed and this revision, you say that no instruction. What to do?
Yes, exactly. But the petitioner, both are lady. Complainant.
I am not on merit. You tell me. Why have you said no instruction?
Severely ill. I have filed the medical document since 24. She was severely ill and she was bedridden. No communication was there between the council and me.
What is the check amount?
Check amount.
Where is the, there is no much.
Compensation amount was modified to 1 lakh 10. I have already deposited the draft for 1 lakh 10 before the loan. Now the petitioner has been arrested. Subsequent to the order of dismissal, the NBW was issued by the trial court, and by virtue of that NBW, she has been arrested on 2/8. She is in custody since 2nd August 25.
But you have said this, but there is no medical record. There is nothing. Where is that? Because you are in custody, therefore you are creating all these things.
No. It's a previous document. It's a creation. It's a Pune document.
What is the name? What is the name?
Boyjanti Das.
Boy,
Boyjanti Das.
no,
Boyjanti Das.
the name is something
तो
different.
मुझे ये जो delay condon आइए
Boyjanti Hota.
Das जी तंगरा ये
You have to bring all these things. Once I have dismissed now, now the trial court is executing it. She is married to Dilip Kumar Das. Obviously, maybe.
modified draft already in Corsair ji. She has already undergone substantial.
You have to tell there. What can I do?
Said it file kolu. The trial court did not accept.
Okay, I
Said
simply.
file court again return kole. But your lordship.
See, you have been convicted. The appeal filed by you has been dismissed. Thereafter, you filed the revision. When the revision was taken up, you say that I have no instructions. I recorded that and disposed it up.
Due to communication gap arising out of the.
Now you are arrested, therefore now instruction has come.
It's a fact. It's a fact. Not under this circumstance. Not your lordship recall this order. Not I am handing
Yes,
over the.
you are appealing.
Handing over
Yes,
the.
my lord.
Ready to settle the dispute.
Yeah.
Ready to settle the dispute.
Yes.
Yes, my lord. Sure.
I'm handing over this 1,10,000, the modified compensation amount. If your lordship is proposing for more, little bit
Show
more.
me. Show me. I will indicate and give you
My lord,
liberty.
you may serve on us the recall petition if the.
I will not recall, but I will simply say whatever development is in side of by the order dated.
Serving copy.
By the order dated 10/7/2024, the revision petition filed by the petitioner has been dismissed by dismissed. While dismissing the revision petition, the following order was passed. Order. The counsel for the petitioner submits that pursuant to the dismissal of the revision petition, the trial court has issued warrant and the petitioner has been taken into custody since
2nd August 25.
2nd August 2025. Thereafter, the petitioner has moved the present application, that is IA number 832 of 2025, seeking modification of the order dated 10/7/2024. In the application, she has the petitioner has contended that the petitioner was wherever you say that you are not well, nothing you have not said.
Well, in that,
The application also you have not said anything.
in this application, I have stated.
Wherever you
that
said
in-
that
in-
you are
in
not-
IA 844/24 for condemnation of, I have already explained everything.
Which is the modification application?
Modification 831. IA
How
831.
many applications you have moved?
Or to three IAs. One is for recall.
Which is the
modification.
recall application you tell me?
Recall number 831.
831.
831
Contended.
and for bail
832.
832.
That
I have already stated.
the contended that the petitioner was hospitalized. What?
Hospitalized.
You have not said anything. That's the whole difficulty. Who will help you?
Three medical documents I have
But
filed.
where have you said those things?
Yes, not in the IA.
Where have you said it?
IA 844.
You're all the story. He has been arrested. Blah blah. So many things you are saying.
IA 844 I have it.
844 is which application?
For condemnation of delay.
I am talking about modification application.
Modification.
Where have you said in
In
modification?
modification also I have stated.
Very poorly drafted. What to do?
Only on 2nd August 25, paragraph 4, when the petitioner was arrested and remanded to jail because she inquired about the inconscious, the order of dismissal, the trial court.
The subsequent developments you are saying. You are saying now
There is
he
no
has been
development.
arrested, therefore he modified.
In paragraph 5,
Where have you said?
due to communication gap for her long time illness, in paragraph 5.
What is the illness?
Illness is the document. Cervical spinal injury plus
Keep it with you.
and
Keep it with you.
liver arthritis.
Keep it with you, don't file it. You keep it with you, don't file it.
No, I filed one of the document.
What will I write? You tell me just. Help me out. What will I write?
I have filed in the
With-
IA double.
I don't know.
That is why
I don't know who can help you.
that is why today.
Right. Okay. Contended that due to the long time illness, he could not contact the council and furnish the instruction. He has also placed on record by way of a memo certain medical document to substantiate the same. On the aforementioned ground, he seeks the appellant, the petitioner seeks modification of recall of the order dated so and so. At the same time, Grand Counsel for the petitioner submits that after the petitioner was arrested, he has prepared a draft of rupees 1,10,000.
That is the modified compensation amount.
Which stands for the modified compensation. He is ready and willing to settle the dispute. The photocopy of the draft is taken on record. Since the taken on record. In view of the aforesaid development which has taken place in the matter and the fact that the petitioner is willing to settle the dispute, it is open for the petitioner to move appropriate application before the trial court seeking grant of bail and bail. Let the trial court by taking into consideration the fact that the petitioner is willing to settle the dispute and ready with a draft of rupees 1,10,000 may grant the petitioner on bail and refer the matter to mediation. With this observation, the petitioner is disposed. You will go to the mediation and pay the money and finish it.
I have got to grant the bail. For bail.
I have said that grant the bail. The trial court will grant you bail and send you to mediation and pay the money and finish it up. That's what I said. Okay.
Publish.
Yes. Next. Application is disposed of. Yes. Yes.
Tinta application. Tinta.
All the applications are disposed. Yes. IA number 844, 851 and 52. Yes. 7.
Item 7.
May I please lordship, my lord? In this case, my lord, I pray for a modification in page number 7, my lord. In place of accused person, it has been stated that NBW issued against a petitioner.
5 to 24 order.
Yes, lord.
NBW issued to?
My lord, against the accused person, it should be against the accused persons. But it inadvertently it has been typed.
The petitioner is accused?
No, my lord.
Then?
Petitioner praying for execution of NBW in the CRLNC, my lord.
Okay. Right on. Petitioner is the informant.
Yes, lord.
Petitioner is the informant in the present case. He had approached this court seeking execution of NBW issued against the accused person. This court, by the order dated 5/2/2024, although disposed of giving direction to the concerned police station for execution of the NBW against the accused person. However, in para 4, in place of the accused person, inadvertently, the direction was inadvertently petitioner is found mentioned. Therefore, she has moved an application for modification. For the reasons stated in the application, the same is allowed. The para 4 of in para 4 of the order dated so and so in place of the petitioner, which is occurring in the second line, accused person should be replaced. Yes.
Item 8.
Order dated 12/4/2024.
Yes.
Order was passed in a Belgium matter. 3 petitioners were there. Petitioner 1 and 2 are the father, mother, and petitioner number 3 for petitioner number 3. This modification petition is filed. Petitioner number 3 could not surrender during the time
Or
stipulated
you need extension.
extension of it.
Uh,
And in the meantime,
But
the case number has been changed because
by the order dated 12/4/2024, while
I will surrender in GR case number 149A, split of case.
that the NBW issued against the petitioners, while the order dated NBW issued on order 5/2/2024. They were directed to surrender, appear before the court on or before
JMFC
15/5/2024. 15/5/2024. Mr. Hon'Ble and counsel for the petitioner submits that petitioner number 1 and 2.
They have surrendered acquitted already.
Petitioner number 1 and 2 has complied with the order, whereas petitioner number 3 could not comply the order. Therefore, he seeks extension of time. But regarding head to the reasons stated in the application, same is allowed. The petitioner is petitioner is directed to surrender or appear before the which court?
JMFC Dasfala in GR case number 149A.
JMFC Dasfala in GR case number 149A.
And A of 2005.
On or before today's on or before 30th of October. 30th of October. Okay. Yes. 9.
Matter. 138 of
You are appearing?
For the petitioner.
Yes.
Lord, there are two things here.
You have given undertaking to the court. And a settlement has taken place. You can't take the court to a ride like this.
Despite our genuine intention, we had our own debts, other people have debts against us.
That's a different story. Why have you, see, you have proposed something and I gave it to them. They have agreed. Thereafter you are making it out.
38 crores was yet to be recovered by my client from against other entities.
That is your problem, sir. What will he do?
That doesn't mean that you will not pay my money. Kindly similar, para 14 of.
I am giving a one more opportunity. If you pay it, I'll drop it. I'll direct the trial to conclude it within 1 month.
Kindly see the judgment.
What is this?
That's irrespective of availability of execution remedy. Still a contempt lies if you are violating the.
Yes, I'll issue notice on contempt of. You can't take the High Court to a ride like this to settle the dispute. You have drafted the settlement deed.
Yes.
And I have circulated to him. He has agreed to that.
Yes. And without any interest.
And see the time you have consumed for this, all this thing. Who will bear it? See, 143, section 143 of NIX says that within 6 months it has to be concluded. And this text is exploited by you, has delayed it. Who will bear it?
Well, right now the trial is at a stage, they had filed on an amendment application. We had filed our objection. Now, for the past 1 month, the order has been pending. Like it has been reserved. It has not been passed by the trial court. Now, there's no delay on my part right now in that time.
And I'll give, in so far as the first matter is concerned, I will give direction to the trial court to conclude the trial within 45 days. 45 days. No, 45 days, and you accept notice in second matter.
Yes.
We'll see. Right. Okay. This is your application, huh?
Our application to time.
No, the first matter. I'm talking about the first matter.
The IM. Yes, that we have filed this IM.
What have you sought for?
We have said we have prayed that only to try, fix the timeline for disposal of the.
Okay. IA number 1844 of 2025. The criminal MC number 3375 of 2024 was has been. No, this is an application for. This is an application moved by.
Look at the
respondent.
Why
Opposite party seeking a direction to the trial court for early disposal of the complaint case. Okay. The CRL.
Let me clarify why it is being delayed.
It's an official succession, de jure complaint. Our secretary, who was the original complaint, he resigned. We appointed a new secretary.
That is your problem
That is
there.
permissible.
That court
they
will
should-
decide. I am not going
No,
to
your
decide
lordship will not.
right now. The CRLMC number 3375 of 2024, moved by the petitioner, was disposed of by the order dated 16/1/2025 on the consent term. The petitioner has circulated a draft settlement deed to the opposite party. The opposite party has accepted the draft settlement deed, and on the basis of the settlement terms, the matter was disposed of, which the settlement terms is reflecting in para 5 of the said order, which is agenda.
Yes.
Para 5. Para 5. It is also stipulated in the order that in the event the petitioners failed the settlement, the complaint case would be revived. Learned counsel for the petitioner submits that for the financial difficulty which is being faced by the petitioner, they are not able to make good the payment as per the settlement term. Since admittedly they have failed to comply the terms of settlement, the complaint case has been revived and the trial of the complaint case is going on. It is seen from the record that the complaint case was filed when the complaint case was filed. Complaint case was filed on. When was the complaint case filed?
But immediately after your lordship disposed it, after the term was violated by them.
Complaint case was filed on. Date is there.
The lordship may say revived without giving the date. it was
No,
revived.
when was the initially filed?
I
It was
don't have
initially
the
filed
date.
on 11th August 24.
Complaint petition of 2024 when it revived.
The initially filed in the year 2000. It is filed on
2024.
2024. Date is not there.
Date, not I'm giving the date. Date is 14th of August 24.
Oh, no, that is a summon. But it might have been filed before that.
Achha, achha.
That is a summon. Right. Filed in 2024. And subsequently, summons were issued on 11th August 2024 to the accused petitioner. The complaint case is pending since then. Meanwhile, the petitioner accused had approached this court by filing the CRLMC by challenging the summoning order dated August, summoning order so and so. In the said petition, the settlement, petition, the parties have entered into settlement. On the basis of the settlement term, the petition was disposed of. However, it is apparent on record that the petitioner accused has wriggled out of the undertaking and wriggled out of the undertaking given to this court for compliance of the terms of settlement. Be that as it may, it is clear that because of the petitioner's petitioner's at the instance of the petitioner, the trial of the complaint case is delayed for about a year. Section 143 bracket so 2 or 3 of NI Act mandates that every such complaint under Section 138 NI Act should be concluded within a period of 6 months. Therefore, since the trial of the complaint case is sufficiently prolonged at the instance of the accused petitioner, I feel it appropriate to direct the trial court to do well to see that the trial of complaint case is concluded within a period of 45 days. Hence, 45 days. The trial court shall not entertain the unnecessary adjournment to either to the complaint or to the accused, accused. With this observation, the application is disposed.
And the trial is being delayed because the court, London court below is already overburdened with cases.
I don't know that I have given
That's why the order has been resolved for the past 1 month.
whatever. I have 45 days I have given reduction. Insofar as the petitioner, this contempt petition has been filed by the filed by the petitioner inter alia, alleging that the undertaking given to the court by way of settlement terms has been deliberately not complied by the respondent contender. In the present case, the respondent contender approached this court challenging the summoning order issued by the trial court under Section 138 NI Act. While the matter was taken for consideration, the petitioner, the respondent accused, mooted an idea for settling the matter and circulated a draft settlement, which was agreed by the petitioner, On the basis of the said settlement term, the criminal MC number so and so. What is that? Criminal MC number 3375 of 2024 was disposed of by the order dated 16/1/2020. 16/1/2025. It is brought to the notice of the court that despite settlement terms, the contender has violated the terms for which the present complaint, present contempt petition has been filed. Next forward, issue notice to the contender, respondent contender, returnable within 4 weeks. 4 weeks. Don't so accept notice and 6 time to file reply. You file reply. And Mr. Ratho, which paragraph?
This paragraph.
Mr. Ratho has relied upon the counsel for the contemporary respondent submits that
Para 14.
as per the settlement terms, in the event the petitioner fails, the respondent fails to make good the payment as per the settlement term, it was agreed that the complaint case would be revived. In fact, the complaint case has been revived and it is the trial is going on. At this stage, Mr. Rathod and senior counsel for the petitioner, relying upon the judgment of the Supreme Court reported in 2004 1 LCC 360, Bank of Baroda versus Sadruddin Hussain Daya and others submitted. That what have you submitted?
Lord, it is that it is here. Therefore, puts into consent terms and made a decree of the court. Violation of breach or undertaking which became part of the
Submitted
decree.
that violation of breach undertaking or the settlement term
Certainly amounts to contempt of court.
settlement term before the court attracts the contempt jurisdiction of the court, contempt jurisdiction of court. He has relied upon para, which
Para 14 matter.
Para 14 of the judgment which reads as enters. Therefore, issue notice. Yes.
Lord, with the Lord's kind approval.
Yes.
Item 6. And apart from that compensation amount, sentence of 1 year is there. Unless
Do you want me to allow your revision? I have only given limited this thing. You go and do whatever. You settlement means everything will be settled. Obviously, terms of the sentences also will be considered there. Pay the money and it will be settled. Yes. Next. Next.
Bank guarantee details. Your notice has to.
Last order, what was
the investors officer.
Are you
Notice that my rights.
Requisite for issuance of notice, no, the investment by restriction.
You filed?
Not filed.
You will file requisites.
Who? You have filed. You have filed. It is your application.
It's in the criminal office.
No, your application you have to file.
May I suggest one?
Ah.
Your lordship may allow that application.
Bank guarantee.
Either my lords, I will not be able to furnish the bank guarantee. So let it remain state. This cat and mouse game should not go on. Because I myself am guilty of having asked your lordship to modify an order. And now they want modification, so let it be modified. Your lordship may allow that. Your lordship may only record my submissions. That
Why to add to confusion? Let us see. I'll
No,
find out a way.
at all.
Hmm.
This is only killing time and waste of time.
How does it make difference to you?
But I am not being benefited in any way.
But you are not being prejudiced now.
No, it is not a question of prejudice.
Hmm.
Because of my finances having been stopped, my lord, my business has come to a standstill. Then other health problems and others have arisen. Let this litigation end here so that one headache goes. Your lordship may allow that.
His application is for
The bank guarantee.
bank guarantee.
That is what he is asking. My senior is asking. That was the original order of my lord.
Then what will happen? The original order is your application has to be rejected. Then
You know,
your modification application is to be rejected. That's all.
my modification application has already been allowed. Now your
Modification again. Modification again.
Now your lordship.
Original order.
Modification.
That means original order has to
Has to
be
be
restored.
Yes.
Original order has to be there.
That will solve this problem.
That's
because
solve this problem.
I am expected to file a requisites, my lords, for.
No, you will not file. You file requisite. I'll fi-
3 weeks have gone.
I'll try to find out a way out. That's the reason I'm trying. File requisites immediately.
My IA.
Huh?
My IA.
Your IA file requisites. Okay. Requisites within 2
By
days.
tomorrow we'll file.
File it next week. Thursday. Next Thursday. Huh?
That's all.
Bring. Why don't you call the IO? Call here. I'll find out a way.
Let it come next Tuesday or Thursday. Or
Call him personally
That's it.
or online.
That's all.
Let him come. We'll find out.
That's all.
Unnecessary, this is hanging. He can't pay. You know he can't pay. His bank accounts, everything is frozen. And one should not pass such order which will, that is what he says. Pass an order which cannot be executed. If you insist for bank guarantee, see, try to appreciate one thing. Try to appreciate. If you insist on bank guarantee, he is not capable of doing it. And that order will never be complied.
That was the original order of my lord.
That's right, but that time without realizing, that time without realizing, Mr. Panda had said that he has bank guarantee. I made a pass directly. That's a balance order. But subsequently, he got instruction that his entire bank account, everything is frozen, wherefrom bank guarantee will be furnished. So therefore, he moved an application saying that I will give property security. I said, it's all right.
Bank guarantee issued against the property security. So he has the property. He has to place the property, take the bank guarantee. That is the law, my lord.
Let me see let the IO
How
come.
does he know that I have property? I have given the
You are
property.
giving the property.
I have
He
given
has
the
to
property
give that
property
to the bank.
What will you do with the bank guarantee? I tell me.
I have given.
You are the only thing is the amount has to be secured. That's all.
Exactly.
That's all.
Yes.
If he gives bank guarantee or big property security, how are you going to be benefited? You are not going to get the cash to spend it.
In case of my lord, so the
Simple.
recovery, I am benefited by.
Otherwise, you can sell the property also. You can-
Property security, I cannot take as a temporary reminder, sir.
Bank guarantee you can take.
Bank issue in my favor, man. That is their manners.
What will you do? You can't engage that.
Lordship is very much aware of all these things.
No, but how can you engage the bank guarantee?
Once my recovery proceeding will go on, apart from this criminal proceeding, amount should be paid.
Right. See, for the sake of some opposition, don't. Let us have a practical approach.
Yes.
Practical approach. That's the better idea of doing
Yes,
it.
I give him.
See, the problem
Let
is.
us keep manners.
Let him come. Let us find out a practical solution. You pass some order which will never be executed.
Generally,
I know.
It's not one case, man. It's 10, 15 cases like this, man. So, in
No,
the
I'm
option, they take the person, they remove the material, sell it, and take the money.
But we are concerned
Now
about
it is
this.
in the bank, luckily. And that's why police has seized, man.
No, his property will be at
With
stake
due
now.
respect, my lord.
Property.
Insinuations should not be made against my client.
No,
I
but,
object to
I-
my learned friend
Ten-
making insinuations against my client.
I object to it seriously.
Investigation.
And I also consider.
Now, in the stage
I
of
also
such application,
consider
why
that it was my mistake that I approached this court, my lord.
by that moving application?
That was my mistake in coming to this court, my lord. So I am not in
Okay,
a
well, I'll see
position
that.
to do anything.
If nothing happens, then I'll modify it.
Nothing will happen, my lord.
So that these orders will be neither here nor there.
Let us see.
Let us see the IO.
Nothing will happen.
Huh.
The landlord is only making a mockery of this.
If such orders are never to be executed, he will not give bank guarantee, now property surety also. At least property surety is now assured. Even that he will not give. If I modify.
Documents to the.
So that's the whole difficulty. Let him come. Let him come.
Otherwise, the property will see, property will show, okay, they can see the.
Let us see the
In my
satisfaction of
mind-
IO. Satisfaction of IO. We'll see. Okay. 18th. So tell the IO to appear. Yes.
11.
Lords, cannot the IO appear today at 2 o'clock? A phone call from a learned friend.
But I don't think.
Will not the IO
Make
appear
it Tuesday. Make it Tuesday.
Tuesday.
Make it Tuesday. Yeah. Make it Tuesday. Tuesday rakh diya. Tuesday.
Yes, sir.
No, Tuesday. Tell him, don't wait for that requisite. You just said, simply tell.
Yes,
Let him appear. We'll find out the solution. Accordingly, we'll pass the order. Yes. Yes.
11.
On behalf of P. Hon'Ble Das, your lordship,
Sorry?
I am praying for an adjournment.
Okay. Adjournment. 24. How 24 matters are?
Your lordship, I am not aware about that
Okay,
matter.
okay. Yes. Next. So many modification applications. Adjourn. 25, 12.
My lord, 12. 12, my lord, modification for extension of time, my lord.
Extension of time. Last. How many time you have taken?
My lord, only one.
The second time.
For the first time, the earlier on the first order, that is a month time given. This is for the very first time.
Okay. Extended. Time extended till 30th of October. Last and final opportunity. No further extensions are be granted. Yes.
Mature.
13.
Milord, I am in virtual mode. Please allow me. Milord, on the last occasion, the Honorable Court has given me liberty to give the copy to the counsel of the opposite party. Milord, I have approached the loan counsel of the who has appeared in the CRLMC 5170/2024, Mr. A. Tripathi, but he had denied to receive the copy, saying that he is not the counsel of the present case.
But
That is the CRLMC.
you have to serve. See, this is a matrimonial dispute. I will not pass ex parte order. Are you appearing, madam, in this matter? No.
Milord,
You not pass ex parte orders like this.
Milord, only the enter the NBW against the petition, the petitioner. I want to swap this copy in the court below.
Which order you are seeking modification?
5170/2024.
Which order you are seeking modification?
Not the annexure 2, page number 20.
Page number?
20.
Annexure 2.
And annexure 2, page number 20. In the para 4, it is clearly mentioned that, however, it is sufficient to say that petitioner, being a retired teacher, cannot afford to make good the payment of Rs 60,000 accumulated arrear. Hence, on consent, the petitioner is directed to pay Rs 30,000. But before passing this order, already the petitioner had paid 45,000 out of 60,000. But still, this case is present and not.
Have you paid 30,000? Have you paid 30,000?
Milord.
Where is the proof of paying 30,000?
Milord, in the last occasion, I have shown this certified copy. Now,
Last occasion, show me now. The direction was you have to pay 30,000 rupees and keep on paying the regular maintenance, and thereafter you move an application. All the three things you have done.
Milord.
Show me.
Milord, I have a certified copy.
Whenever you paid 30,000 rupees and regularly you are paying the maintenance.
Milord. Before this order, that is the dated 12/11/2024, the petitioner had already paid 45,000. That is more than 30,000.
No, no, I have asked you to deposit, pay 30,000 rupees as well as keep on paying the maintenance of 5,000. You show me that you have been paying it. Then I'll give indulgence.
Before passing this order, already 45,000 has been passed.
No, I'm talking about after 12/11/2024, you have paid 30,000 rupees and you have been paying 5,000 rupees per month. You show me. Immediately I'll give indulgence.
Total amount is 60,000. And out of that, the petitioner has already paid 45,000.
You are not able to understand what I'm saying. You read the order. Read the order.
The para 3 non-council petitioner submitted that the petitioner was working as a teacher.
Have you understood what is your petition is?
Milord.
What is the petition?
Milord, petitioner is that the area maintenance was 60,000 and the petitioner had
You came before this court challenging an order whereby you are directed to pay 60,000 rupees towards the area and 5,000 rupees per month. And I said that you deposit 50%, that is 30%, 30,000 rupees, and keep on paying the regular maintenance, and liberty was granted to you to move application before the trial court for variation of the order. Now you have to show me 30,000 rupees you have paid and you have been paying regularly the 5,000 rupees maintenance which was paid. If you can show me, then I will give you indulgence. Don't bring me, take me here and there. Don't waste my time.
But after that, the petitioner.
After before now, you show me where have you paid 30,000. Otherwise, I'll dismiss the application. Because you are not able to serve the copy of the petition to the lady. I can't, ex parte, I can't modify everything.
On the next day, in the code, next day is the fixed is 14/10/2025.
Why don't you understand? These are maintenance orders. It cannot be modified ex parte. You are the husband. Without hearing the wife, how can I modify? You tell me. That's the reason I asked you to go and move application.
On the next day, on the next day, I can solve in the code below.
You do whatever. Simply urgent.
On the next day, I can file this. Please pass an order.
I am simply urging you to move application. Who stops you? If you have paid 30,000 rupees and you have been paying the regular maintenance, you are entitled to move application. That's what the liberty is granted. You move application. Shall I say that and dispose it up?
Please only pass an order. This is the law counsel of the lower court she should receive this copy.
No, I can't pass ex parte order like this. You are not able to serve also the lady. I can't do that.
On the next day, I can solve this.
Okay.
Milord, item 14, I pray for some more time to file an affidavit.
What affidavit, madam?
In persons to the last order, we were to file an affidavit.
Give 4 weeks time.
Much obliged, Milord.
Okay. And 15 onwards, reports. I'll come thereafter. Okay, thank you.
I may be part of the bench. So that is item 54 and 58, both matters are there. In one case, my look was pleased to direct the government must stop in inspection. But the period under was from the chemical. That inspection was sought for. They are not in this. That is one part.
Let it be there on the board next time.
Yes, one more thing, another case is there. 2 or 3 was there. Individual 2 was there. But conviction was 325. Punishment was 2 years only. One for 2 years, other one for 6 months. Now, 6 month part has already been allowed by this will be good. After inside the proceeding for 8 months, 21 days. That it shows order sheet maybe. And the other person has been was inside of 8 months, 21 days also. But my anxiety is here, whether thereafter they had continued inside the prison or not, that is not clear. Number one, maybe. And number two, that period, that person also 8 months, 21 days.
You are talking of 52.
54.
1 minute.
I'm sorry, my lord.
Report has come.
I think. My lord, what would be 54? 54. 54.
They are alive.
They're alive. What I found, they're alive. That instruction they don't have, I think. But they're alive. And interesting part of it, the person who has been convicted for 6 months, he has already undergone period. That period has been undergone. And the first appellant, he was convicted of 2 years and 1,000 rupee fine.
He has undergone 8 months.
Yes, he was inside. For that matter, maybe next week, any of that, maybe today. May not be possible.
It is from the record. It is verifiable.
So, my from High Court.
Oh, then okay.
This is over. And regarding only the status that person, LI part will take. What's his name?
LI part, this is there. 54. These the matter. The parties to ascertain the period the appellants have undergone.
Yes.
On the by next date. Okay. Please say.
No, and second on 55, that was the direction to obtain instruction. They have not yet received.
I'm just getting all the. Okay. You are free for today.
My lord, may I pardon to mention item number 51, my lord. I'm appearing 51.
51 report, no?
No instructions from
What do you want?
Because query may be appointed, no instructions from the appellant.
I'll just see. I'll just go through and just see. If it is required, I'll do. Yes. Report. Yes. 15. That's the report. You are 15?
Yes, your lordship.
15. How many appellants are there?
Two, your
Two
lordship, the husband and as well as the wife.
This
One.
is the 3. 7. Oh, they are there. They're alive. Report, huh? Alive. Duty suffering, you know,
Soft copy of LCR may kindly be provided. Soft copy of LCR.
Yes, soft copy of the. You can take it, huh? You can take it.
16.
16.
All three of us.
All three. Okay. All the three appellant expired. Wait, huh? 17, 17, 18, 19, 9. Chalo.
20.
20 kono? Yes, he is there, alive. Yes.
21, 22.
22, 29, 23 there.
23 there. After 3 appellants, only 8. Appellant number 2 is alive only. 23 in item.
2 is alive.
Oh, rest
Right.
1 and 2 and 1 and 3.
Kulvinder Singh died on 9/4/2023 and Rajam Pradhan died 10 years ago.
Yes.
Okay. 23. Lead matter. Second matter there.
Sole appellant alive. Second item.
Alive.
Yes, sir.
Second item.
24 is not.
25.
25 was, na?
25 re 2 appellants expired.
Both the expired. 25, na?
Yes, sir.
Let's see how many.
2 only. 2 years.
Yes, both of them died.
I want to make a mention in lordship, item number 21.
I am in which item now? 25. Let us talk about 25 first. Okay. Wait. Yes. Next.
26 to 29.
That privilege is only to given to the senior counsels. So they are busy. They can come and do it and go. Are you a senior? Now you want to be a senior, then I'll designate you. Then please have patience and sit down and listen to the court and learn things, okay? Never ever interject when the court proceeding is going on. Okay, this is not fair. Yes, next. 26, 20, 30.
30 reports available allied wells.
First present, yes. 30, 30. 31. He's staying. 31 is also there. 31 is there. 32, 33.
33 applicant
Demise.
set, 2 and 3 are alive.
No, there are 4 applicants, na?
Rest 3 are alive. Only Kunjo Nayak is dead.
Then applicant number 1 died. Kunjo.
Yes.
Kunjo has died, huh? And
Kunjo.
the rest 3 are there. And 34. Nahi, 36. 36.
Dead duration.
Dead.
Sole applicant is dead.
Sole applicant?
Sole applicant.
Died. Everything. Huh? 37.
When your lordship, as
Alive.
as per our instruction, the appellants are alive.
Alive.
We may be permitted to take the LCR.
Yes,
soft copy of the LCR.
Soft copy, alive. Okay, ready. Get ready, huh?
10 days time.
Yes.
when-
38.
38.
Alive. All questions are alive. 39, nahi. 40.
We have given the reports.
They are alive.
Yes.
Yes. 41.
41 have given the reports.
Dead, huh? Sole appellant?
Yes, sir.
Sorry.
This is 41, na?
41.
देखो देखिए भी वही है प्रॉब्लम तो लेवल पे yes right with it yes 42
In 41, he's not dead. No, his whereabouts are unknown.
dead na it is dead
41.
dead about 20 years
41. This
41
Birsa Kishan.
huh
Birsa Kishan.
41 na 1 minute 41 what is this then
This is, they're not able.
Duita Saha well-being of Duita Saha ये कौन सा दिया है
I'll just handle.
but what is this then 41 criminal appeal of 92 of 4 to 2010
92 of 2010.
hmm
Birsa Khan, your lordship.
Birsa Kishan
Birsa Kishan.
but this report says that well-being of Duita Saha who has died 20 years what is this then
Probably there's a misplaced solution. I'm just handling.
अरे देखो क्या है
See, probably that is the report in CRA. This is CRLA. That is why
CRA.
there is a confusion.
hmm
Connected order, 208
Good.
of 2005 years.
Huh?
It's a connected matter.
Connected matter.
There is no.
208 of 2005.
it's not listed
It's not me.
disclosure देखी दियो कभी कुछ भी दे दो यार
41 said that they could not.
difficult to certificate देखियो इधर होची CRLA number 92 of 2010 है ना ये रिपोर्ट अलग रखो सी तय देखी दो चेक करो it's very problematic and next is 42 42 रे Mikhail Naik now present
Is alive? That is older, but alive.
33 report is not there 40
43. So, so CBI matter. And this man is of West Bengal.
yes what do you say
Lordship, we have received the instruction regarding well-being of the appellant. We have received the instructions regarding well-being of the appellant.
Died?
No, he is present, Your Lordship. He is alive.
Alive? Oh, that's what.
He is about 85 years old, Your Lordship.
95 years?
85.
85. That counsel for the respondent CBI. submits that the appellant is alive and he is at present 82 years of old. He has placed on record the report. Yes. Yes. Yes, next. 44.
44.
Alive. 44 alive. 45 alive. 46 are also alive. 47. Nee. 47 sole appellant. What is the name? Ohalya Das. Ohalya Das expired on 1/10/2019. Ohalya Das. Huh? Wait it. Next. It will be 49. So, right. Yes. Yes, 49. Then 50. Here. 51. 51 you said, na? You say no instruction.
No instructions.
But you have file with you.
My lord.
Do you have file with you?
Yes.
I'll appoint you as an amicus. You are the best amicus. What is your name?
Asutosh Mahanti.
Asutosh Mahanti, Lieutenant Counsel. When you got enrolled?
2017.
17. You can do it. No problem. Asutosh Mahanti, Lieutenant Counsel for appellant, submits that despite his best efforts, he could not get any instruction from the client, from the appellant. Therefore, he seeks a discharge from this case. Although his prayer is deserves merit, but on my request, on the request of the court, he has accepted to assist the court in the capacity of amicus curiae. Amicus curiae, lease the and request for a short adjournment. When will you get ready? 1 week?
Moment.
2 weeks after. This is 92 matter, 1 week only. Get ready. 1
2
week.
weeks, my lord.
You get ready. If you can't do, then I'll accommodate you. But you start doing it. Prepare a written note also, small written note. You have the full file with you, or you will take. You have full file with you. Okay. Prepare a small note and try next week. If it doesn't happen, then I'll give you 1 more week. One next week. 92 matter next week. Okay. Yes. 51.
52.
52. Yes, madam. You are ready for? Then I'll take you 1 minute. Yes, next. Once you just call.
52, 53.
53. 53. You wanted to say something? 53?
21, my lord. 21. Item number 21.
Where is?
Report.
Report. Report. Its report hasn't come. Report hasn't come. Yes. 52. Oh, okay. Report to nahi na? I was hearing. Hearing. How get the? Yeah. I don't want to keep further judgment. I'm getting judgment. তারপরে আমরা হ্যাঁ দেখি ইউনিয়ন ব্যাংকের 2টা আছে anyone, any short matter is there? Any short, small matters? Yes, sir. You're waiting for some matter.
I'm serious note 68.
What is this matter?
Conviction under section 366 and 374. 3 years and 7 years.
That is long matter, little long matter. Yes, yes, sir.
Item number 36.
Yes.
Our instruction is for the petitioner died. So your lordship directed last.
Abated, it's abated. Died, abated. Yes, madam.
Your Lordship.
60.
Conviction under section 376, 7 years of jail and regress imprisonment and 2,000 fine, Your Lordship.
Okay.
No knowledge of welding and whereabouts.
Have you prepared some written?
Just got the.
You prepare it, huh? Prepare because you prepare it and hear it. Okay. This is 2002 matter. Prepare it, huh? Okay. Anybody is there?
Your Lordship, item number 25. My senior is out of station, therefore he prays for an adjournment.
20. Huh? They both of them died. Both the appellant died. It's abated. Okay.
So item number 60 as well.
60 also. 60 she is appearing. No.
Item 30, Your Lordship, on behalf of my senior Mr. P.K. Pai, Your Lordship.
30.
On last occasion, it was directed to obtain instructions.
It's alive. I would hear. Madam, written note boni jodi bachalo.
My lord, in item 61, I'm appearing on behalf of Mr. K. Boral. We have sent a notice to the appellant and his whereabout is not yet found.
61.
It has returned to us.
What is the age of the?
My lord?
What is the age of the?
My lord, I have no instruction as the file has been missing in our chamber.
You collect, let the council for the 61 level. Let the council for the appellant submits that they are staying in their village.
My lord, we have sent the notice
wants to
to be returned.
reconstruct the file. He is permitted to take the soft copy of the record and leave the matter for him. Take soft copy and I have given it. Okay? Yes.
On item number 39.
Oh, see, I don't want to.
Item 39, the appellant is alive.
Item
39, appellant is alive.
39.
Yes.
That is reported. Huh?
Yes, ma'am.
Alive, huh? See, I don't want to reserve further judgments because about as it is 20 judgments are accumulated. Unless I finish it, is overlapping things. So therefore, let me finish it immediately within this weekend so that Monday I can add something.
Pardon, my lord.